This time it was for real. This time it was for real. Please be seated. I told him this time it was real. All right, good morning.
Good morning.
All right, Mr. Durrell. Good morning.
May it please the court, Dustin Durrell, and my client is Mr. Tommy Lucas. We do have a written plea agreement. If I may have just a minute, have Mr. Lucas sign it.
Go ahead.
Thank you, Your Honor. At this time, Mr. Lucas would admit the violations of probation with the understanding that probation will be revoked and terminated. He will be sentenced to 1129, forfeits any time served that he currently has on both of those cases. Your Honor, there's 2 BOPs. I'm sorry, I don't have the case numbers memorized. But the cases will run concurrent. It's 1 year each count each case, everything to run concurrent with each other. And with Walton County case, I believe that's 25 CF 133.
And
Oh, any financials outstanding will go to collections.
so the 1129, does that start today or from the date of the arrest on this VOP?
That does start from today. I discussed that with the state. He's not getting credit for time served on this arrest either, Your Honor.
Okay. All right, so it's essentially a new sentence beginning today.
Yes, Your Honor.
Okay. Is that the state's agreement?
It is, Your Honor.
All right, raise your right hand for me, please. Do you swear affirm, testify truthfully in this matter under penalties of perjury?
Yes, sir, I do.
Okay. And you put your hand down. You heard what Mr. Durrell said, and you signed the written plea form.
Yes, sir.
Do you understand by this plea arrangement, and these are both VOPs, right?
Yes, Your Honor.
Okay. You understand by this plea arrangement that you're admitting the violation?
Yes, sir.
And that says to me, Judge, I violated just the way the affidavit report says I did.
Yes, sir.
Do you understand by doing this, you're waiving your right to a hearing where the state would have to prove your violation?
Yes, sir.
Now, one of the very important terms of this is that you're waiving all credit that you may have for time served.
Yes, sir.
And your sentence begins today. Do you understand that?
Yes, sir.
Okay. So even the time you've been in jail since you've been arrested on this VOP, you're sitting behind, and this is a new sentence beginning today with this plea.
Yes, sir.
You agree to that?
Yes, sir.
Okay. And your financials will be sent to collections 90 days after your release. And this is concurrent with your Walton County case, and there will be $200 cost of prosecution added to whatever outstanding costs that you have in the case. Has Mr. Durrell answered all your questions about the plea and how it affects you?
Yes, sir.
Satisfied with what he's done for you?
There.
The court will find the plea to be freely and voluntarily entered into and will accept the plea. Thank you very much.
Thank you, Your Honor.
Anything else for you, Mr. Durrell?
I believe that's all I have, Your Honor.
All right, well, if I don't see you before the holiday, have a happy holiday.
You as well. Thank you.
All right, bye-bye. I think I've got, Ms. Barrington, I think you've got Blake Martin, or are you covering for?
I am covering this morning, Judge.
And that's Mr. Davis, correct?
Yes, Judge.
All right, Mr. Davis, you ready?
Yes, Your Honor. Good morning.
Good morning. All right. I think we're here for status, right?
We're here for a status. The court previously entered an interim order on the in-camera review, and then the court entered a subsequent order on September 26th, sir. So we're here for that. And I also filed a motion for modification of the conditions of my client's pretrial release.
All right. And hold on just a second for the court to get documents up here. All right, and so my reading of the order from 9/26 is that we're supposed to have a hearing today on the in-camera view, but I'll have to tell you, I didn't receive the information to review until about 4 o'clock yesterday afternoon, so I haven't had the chance to look at it.
Did the court receive that from the state?
An envelope was delivered to my office yesterday at after 4 o'clock.
Okay, I would ask if the state provide that to me as well.
It was the in-camera review documents with the protected information. So I believe Ms. Bosso dropped it off with Judge Stone's office yesterday. It was not provided to Mr. Davis because that was part of the in-camera review. Protecting the information of that OCSO officer. The only question for today, in my understanding, is whether OCSO violated ICAC standards, specifically whether the prior use of the images had a consent form attached prior to use of those for the operation. So
Well,
Ms. Bosso dropped those off yesterday with Judge Stone's JA.
I believe the court has to first decide if the court's going to grant any reconsideration. And I want to note, Your Honor, if I may, sir, and I don't want to speak out of turn, but their second motion for reconsideration is really a request for reconsideration of the denial of their first reconsideration. So it's strange as to how many bites of the apple they're seeking.
Well,
You
and
know,
I think, Mr. Davis, the issue that we need to address very clearly was addressed in the court's order, which I was expecting, or according to the order, guidance or briefs no later than the close of business Tuesday, October the 7th is what my order says.
Right.
And I said that at the time the order was drafted, the progress docket had 343 entries, and as successor judge, I did not have the benefit of presiding in the 32 previously scheduled hearings. And
Yes, sir.
in order to assure efficient review, then I needed those briefings and statements. So the bottom line here, as you read the order, is it has now fallen to me to make a determination of this, and my understanding is that I must determine this de novo based upon the predecessor's judge's determination that they would not consider it. And so I believe I have to address it de novo.
Well, from my perspective, Your Honor, the court should only address the request for reconsideration of the order denying reconsideration.
And you filed that before October 7th and sent that stuff to me,
No, sir.
and the state didn't either,
Right,
and they delivered the in-camera stuff yesterday at 4:30.
Right.
For a hearing today.
right.
All right, so how much time do y'all need to do what I previously told you to do? Starting with the state, when can you get it done?
Your Honor, if I just may ask for clarification for.
Read the order.
For the statement of documents, is that what the documents we're relying on just for the in-camera review, or everything which the court to consider for the entrapment motion?
Read the order. The order is clear and unambiguous of what I requested. When can you get it done?
The state will be able to file a statement of documents by the 18th.
Paragraph 2, the state and the defense are ordered to submit any arguments, brief, or other guidance the parties deem applicable to this court no later than. When are you going to do that?
The state can also file that by the 18th.
All right? Mr. Davis?
I'm going to need a little more time than that, if I may, Judge. May I ask for the 26th?
Yes, sir.
Thank you, sir.
All right. Madam Clerk, indicate in the notes clearly and distinctly that the state will provide their materials December 18th. And the defense by December 26th.
Yes, Your Honor.
And we'll reset this for January 15 at 2 o'clock. And at that time, we'll have a full hearing on the matter. That way, I'll also have time to adequately review the in-camera materials, if necessary, after receiving each party's briefs and arguments. Please read my order and comply with what my requests were and directions were.
Your Honor, may I address the court, please?
Yes.
I would ask that the court direct that the briefs be e-filed and so that it's provided to both sides.
Absolutely.
Thank you, sir.
Would the court have any objection to the state also having until the 26th?
Say again?
Would the court have any objection to the state
If
also
that's
having
what,
until the 26th?
I'm letting you set the deadline because then there's going to be no issue.
The state would also ask for the 26th, Your Honor.
All right? And we'll set it then for the 15th for a hearing. And after I review your arguments, then I'll let you know specifically what we need to do on the 15th.
Your Honor, may Mr. Martin and I appear via Zoom, please?
I will make that determination after I review your materials and make that decision. Your client would just have to see the nature and extent of what the court determines is necessary. Now, if that 15th date then puts you in a hardship for travel and so on, then I'll be willing to continue that, but until I see exactly what it is, if there's substantial materials and documents to be shared, I just have not found that in this courtroom to be a good way to proceed.
Yes, sir.
Okay?
Yes, sir.
All right, thank you very much. Now, what about the pretrial motion? I mean, excuse me, the pretrial release motion? Ms. Barrett?
Yes, sir. Yes, sir. I have that as well. I have two witnesses that should be in the Zoom lobby.
All right, Ms. Berrickman, what's the state's position on that motion?
Judge, we'd object to remove the GPS device, and the international travel, but we wouldn't have an objection to the defendant traveling for work as needed within the country, provided he give advance notice to pretrial supervision.
Okay. So, Mr. Davis, it sounds like they have consent for national travel, but not the removal of the device. Who are your witnesses?
Lynn Usie, USIE, and Tiffany LeQuay.
All right, who do you want first?
It makes no difference.
Lynn
Ms.
Usie is coming into the conference.
Thank you.
Lynn Usie, please open your camera and unmute yourself.
I'm messaging him now, Your Honor. That's my boss, and he's coincidentally moving today.
Okay, I'm on.
All right, I'll need your camera on, sir.
He's also remuted himself.
Yeah, my camera's not coming on.
Yes, sir, I show the camera to be blocked on your end.
There we go.
There we go.
Sir, are you located in the state of Florida?
No, sir. I'm in Louisiana.
All right, sir, I'm about to administer an oath to you in the state of Florida to testify truthfully. Do you agree to accept this oath in the state of Florida, be responsible for any violations of this oath in the state of Florida? Those violations could include prosecution for perjury or sanctions such as contempt, including a financial penalty or incarceration.
Yes, sir.
Raise your right hand. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
I do.
All right, and you put your hand down. Mr. Davis, you may inquire.
Thank you, Your Honor. May it please the court. Sir, would you please state your full name?
My name is Lynn Usie.
And do you know Mr. Blake Martin?
I sure do.
How do you know him?
He's my employee.
Sir, you're not in the best cell coverage. You might want to relocate yourself. How long have you known Mr. Martin for?
Blake's been working for me for right about 5 years now, plus or minus. I don't know exact date.
Okay. And what company do you work for?
For procedural, SEADRILL.
And how long have you worked for Cedro?
Procedural for 19 years.
And what is Mr. Martin's current position prior
He's
to promotion?
Blake is a senior materials handler prior to the recent promotion.
And what position has been offered to him, sir?
He's going to be a materials handler. He's going to be more of a manager, a supervisor, and he's going to be required to travel the globe.
Okay, and can you give the court more insight as to that and what the expectations are?
Yeah, Cedro has numerous land-based facilities around the globe, that being Singapore, Africa, Brazil, Malaysia, the Middle East, and we actually store a lot of our inventory there that belongs to our offshore rigs. So Blake's job is going to be to travel to these different areas, take the inventory, count inventory, account for it, ship, receive, just all the different stuff that, basically the same stuff he does here in the States, he's going to have to do it elsewhere.
And what kind of work would he be doing other than what you just described?
It's going to be a lot of travel. Definitely, travel is going to be a big part of it. But mainly, it's going to be on shore. He's not going to have to go to the rigs, and I'm not saying he will never have to, but his job is going to be on shore, and basically, he's going to he's going to be accounting for all the inventory that's stored there for the various rigs that we own.
Okay. And in the times that you've supervised Mr. Martin over the years, is he a valuable employee?
Very valuable. He's definitely an asset to the company.
And have you found him to be trustworthy in connection with the work that he's done for the company?
Definitely, yeah. He's very trustworthy, and actually, he's a great employee. And he was actually the first one on the list that we even considered for this opportunity.
Did you, in fact, ask Mr. Martin to apply for this position?
Yes.
Okay. And if Mr. Martin is unable to accept this position, will that be harmful to his career?
It shouldn't be harmful to his career because we hadn't replaced him just yet. But if it lingers in any way, I do have to have somebody in place on either position, either to take Blake's place or the position globally.
And can you tell the court, please, how this position, if he's able to do it, would advance Mr. Martin's career?
Yes, it advances him a lot. He's actually where he's at now. He's kind of a materials handler. He's working with 3 or 4 coworkers. Behind a supervisor that's actually reporting to me. And with this new position, he's actually going to report up to my manager, who is based in Houston, with a dotted line to me because he's going to be based in Louisiana. He's going to office here until he's required to travel back and forth. The opportunity for moving up into a senior manager or a management position is very, very great in this role. Much more than where he's at now.
Has Mr. Martin historically always done what you've asked of him?
Yes. No, he's done that and above.
All right. Thank you, sir. Thank you, Your
He's
Honor.
he's very proactive, and he's a guy that thinks outside the box, and he's willing to do whatever his job entails.
Thank you, sir. Thank you, Your Honor. I'll
To
turn-
inquire,
Just briefly, Mr. UC.
speak up loud now since you're away from that microphone.
Mr. UC, you mentioned that he'd be doing some international travel. Is there a particular area that he'd be traveling to?
It's not a particular area because we have land-based facilities, including Brazil, Norway, Africa, Singapore, Malaysia. So it's really gonna depend on what inventory we need Blake to account for at that time, and then that's where he's gonna travel. But for the most part, he's gonna be based in Louisiana, in the office that he's currently in now. It's just included a lot of travel on this new position.
Approximately how many times a month would he travel internationally?
I would say probably once a month.
I'm sorry, sir, could you repeat that?
Once a month, minimum.
Thank you. I don't have anything further.
Redirect.
No, Your Honor. Thank you.
Is witness released?
Yes, Your Honor. Thank you.
Yes, Judge.
Thank you very much, Mr. Yusi. Good day.
Thank you.
Thank you, Lynn.
All right, Ms. Lacroix, if you'd open your video and unmute yourself, please.
Yes, sir, I'm here.
Good morning. Raise your right hand, please. Do you swear or affirm testify truthfully in this matter under penalties of perjury?
Yes, sir.
All right, you put your hand down. Mr. Davis, you may inquire.
Thank you. Ma'am, please state your full name.
Officer Tiffany LaQuay.
Ma'am, how are you employed?
I am an officer with pretrial supervision,
And how long have you been so employed?
going on 11 years now.
Thank you, ma'am. Are you familiar with the defendant, Blake Martin?
Yes, sir.
How do you know him?
I've been supervising him on my caseload since he was placed under a pretrial supervision, which was June 19th of 2021.
All right, so to be clear, you've supervised him the entire time since 2021?
Yes, sir.
All right, and how would you describe Mr. Martin's compliance with all the requirements of supervision?
He has been fully compliant. I don't have any supervision concerns. I haven't previously had any concerns, nor do I have any current concerns of supervision.
I understand no one can predict the future, but as a result of having done this for 11 years, do you have any concern about Mr. Martin if the ankle monitor is removed and if he's permitted to travel?
No, sir.
All right, thank you, ma'am. And is there an upcoming change in the status of ankle monitors for out-of-state defendants?
Yes, we just switched vendors, so the new device that he's going to be getting will have to be placed on him. That is going to, the difference in that is that it's not going to be waterproof, and that we are not going to have global vendors available to troubleshoot the device in the event that there's an issue.
All right, thank you, ma'am. Is there any consideration of maybe not using those out-of-state?
As long as he's in the United States, then we should be able to troubleshoot it in the event that there's an issue. But if he is not in the United States, that's going to be difficult to troubleshoot the device.
All right, and based on your dealings with Mr. Martin over the years, do you support his request?
I can't speak as to whether or not I support his request, only that he has been compliant and that I don't have any supervision concerns that would lead me to believe that he is a flight risk at this time.
All right, thank you, ma'am. I have no further questions.
State wish to inquire.
No, Your Honor.
All right. Witness released.
Yes, Your Honor.
Thank you, sir.
State,
Yes, Judge.
thank you.
Thank you, Mr.
Clark. Good
Tiffany.
day. Arguments?
Your Honor, effectively, Mr. Martin, through his father, has posted a $30,000 cash bond, which, you know, the 10% rule is tantamount to having posted a $300,000 non-cash bond. Mr. Martin voluntarily surrendered himself to the Okaloosa County Jail. He's been on pretrial supervision for some time now. June 30th, 2021 was the first notice of supervision. The court previously, on August 30th of 2021, granted in part a motion at that time to modify conditions of pretrial release by way of lifting the house arrest provision of that. And I will note to the court that there have been no problems, and Mr. Martin has, in fact, complied with all of the conditions of his pretrial release. He's resided in Chauvin, which I probably pronounced incorrectly, Louisiana for the majority of his life. He lived in California for a short time, another state for a short time, the latter when he was displaced due to the hurricane. He's been in a relationship with his fiancée for 10 years. They currently reside together. He's residing in a property owned by his father, which he is renting to own. He's been employed by Cedro since 2019. He currently travels from his home to New Iberia, Louisiana, 70 miles each way each day that he works. I've provided a signed copy of the job offer as Exhibit A and the job description as Exhibit B. Obviously, this will boost Mr. Martin's career. He has no prior criminal history whatsoever, and I respectfully think that's relevant for the court's consideration. So I'm looking at my notes. I don't want to repeat myself. In order for him to accept the position, he does have to have the ankle monitor removed and be able to travel internationally. Judge, I realize that these are serious charges. I'm completely aware of that. That being said, obviously he's presumed innocent. And I think the most important part, and obviously the court's been doing this a very long time, I'd suggest to the court that most people who are going to be flight risks and run are going to do that anyway, irrespective of whether or not they have a ankle monitor on that, can in fact be removed, and irrespective of any other conditions of pretrial release. I'd suggest to the court that Mr. Martin's compliance with all conditions imposed by the court since 2021, which notably, I have a count somewhere in my motion, but I can't seem to find it. Well over 1,000 days has shown that he's going to do what he is supposed to do. Unfortunately, this case has extended out longer than any of us would have liked. The state's second motion for reconsideration has been pending since last August of 2024, and we're respectfully requesting, based on Mr. Martin's prior compliance, his appearing before the court all this time, the $30,000 cash bond, Ms. LaQuay's testimony that he has, she doesn't have any concerns and that he's been fully compliant, that the court please grant this motion so that Mr. Martin can advance his career pending the resolution of this matter.
State.
Judge, as Mr. Davis mentioned, Mr. Martin does reside in Louisiana. He's been charged with 1 count of using a computer to facilitate or solicit sexual conduct of a child, unlawful use of a two-way device, and transmission of harmful materials. It's worth noting that defense did contact our office before the defendant was arrested to negotiate bond conditions, and the pretrial conditions are what was negotiated at the time. The state agreed to a lower cash professional bond, and the defense agreed to wear the GPS monitor. So that was part of the agreement of his bond conditions. He doesn't have any ties to the area. He's facing multiple serious felony charges. Certainly understand Mr. Martin's wanting to get promoted and move up in the world, which is why we don't have an objection to his request for travel within the U.S. with advance notice. But without the GPS device on his person, we cannot adequately ensure he's abiding by his conditions, given he resides in Louisiana and may be traveling all over. So we do believe that's the least intrusive sanction necessary to assure his appearance for trial, and we'd ask the GPS to remain on and he not be allowed to travel internationally.
Any rebuttal?
I'll just note that Mr. Martin would continue to have an obligation to contact Ms. LaQuay weekly, which he already does and will gladly continue to do so. And he'll gladly do anything else that the court requires, such as, and I include this in my motion, such as providing itineraries to Ms. LaQuay, providing hotel information to Ms. LaQuay, anything that's needed to alleviate any concerns. And again, he doesn't have any ties to the community. The state's absolutely right about that, Judge, but he's always resided in Louisiana at all times, material to this case, and he's continued to appear, and he's continued to comply. So while he doesn't have any ties to Okaloosa County, he's done everything that he's supposed to do. Thank you, Judge. Thank you for your time.
The court will grant the motion, provide the additional requirements. So essentially, what the court's doing is requiring that all information regarding entry and exit, travel, residence, and other must be provided to pretrial before it happens.
Absolutely.
I think that's contained within the current, but let's be sure when you provide the order, you run it by the state, and those
course.
conditions are provided in there. And the additional provision is that at any point in time, pretrial is authorized to require him to provide evidence of his present whereabouts by whatever means they direct.
May I ask one point of clarification, Your Honor?
Yes, sir.
When the court says entry and exit, is that entry and exit to the United States or? Okay, so he's to provide his information regarding travel out of country. He doesn't have to in country, although.
He has to in country as well.
Okay.
Wherever he's going to be, he needs to tell pretrial before he leaves.
Yes, sir.
But the entry and exit of the country is more important because pretrial may get a phone call from Border Control about his entry and exit because he's out on bond.
Yes, sir.
And they need to be aware of that so that they can make appropriate responses.
I understand, Your Honor. I just wanted to clarify as to how to write the proposed order. I am not trying to.
No, I understand. But my point is, if I'm going to do this, he needs to be aware that anytime they call, he's going to have to provide proof by whatever means they ask where his location is at any time.
Yes, sir.
Okay?
Yes, sir.
Anytime, I'd just like to add that anytime I've ever even left the state or the area, I've let Mr. Quay know, even if it wasn't within check-in times.
Yes, sir. Well, and continue to do so, and let's run that order by the state before you go. Part of the
Yes,
court's
sir.
consideration, this is the long time it's taken to resolve this case, and the fact that the testimony of the pretrial officer that they're in 4 years and 6 months, there have been no violations at all. The court's taken that into great consideration under the circumstances. All right, thank you, good day.
Thank you, Your Honor. Have a good day, sir.
Thank you so much.
I see Ron Johnson on. Do we know which case Mr. Johnson's on today?
I believe he's also on this case.
He is, Your Honor. He's
I'm
co.
sorry, I didn't let him in. I'm sorry about that. Mr.
That's okay. We'll let him know, Your Honor. Thank you
Okay,
so
I
much.
apologize.
No apologies necessary. Thank you, sir.
Thank you, good day.
Good day, sir.
All right, Mr. Switek.
Morning, Your Honor.
Good morning, Mr. Switek.
Glenn Swiatek on behalf of Graham Scott, 2010 CF 585. This is an expungement case. Mr. Scott is appearing by Zoom. The petition and the proposed order were previously provided to the court, and the court requested a hearing on it. Mr. Scott, if you can unmute.
Yes, sir.
Yes, sir, I set it for my ordinary hearing as I do because I didn't see specifically a waiver by the state. Does the state intend to traverse or demur the petition?
No, sir. May I inquire if there's anyone from the back quarters present?
Yes.
Okay. Is anyone here that's a representative of the restaurant, the Back Porch in Destin? Okay.
Your petition is granted. I've signed your order.
Thank you, Your Honor.
Thank you, Mr. Scott. Good day.
And that's all I have.
Thank you, sir.
Anything else, Mr. Switek?
That's all I've got, thank you.
All right, thank you. Mr. Catalanic?
Good morning, Your Honor.
Good morning, Mr. Catalanic.
I have an inmate, Your Honor. It's Mr. Brian Walker Pippin,
Pippin?
P-I-P-P, yeah, I-N. It's not Scottie Pippen. And Judge, it's 23 CF03. Mr. Pippin, how you doing? Good. How are you? Thank you, Your Honor. Your Honor, what I would like to say about this case, it's a 2023 CF03. It's a 2023 case. He was put on probation, Your Honor. It was aggravated assault, and he got 4 years of probation, Judge. He served 2 years of that probation, Your Honor. He's been in the county jail now for a little bit over 60 days. It's a technical violation for dirty urine, Your Honor. He didn't do anything close to what he was accused of back in 2023. And, Your Honor, he's not a flight risk. He's never failed to appear before.
Well, please approach. Yes, Mr. Catalanic, I believe that based upon the underlying charge and 78406, and I believe it's subsection 8, prohibits the court from granting a bond based upon the underlying charge with the violation. So I can't give him a bond.
Yes, Your Honor.
And so that's, I'm just not permitted to by law until the violation is resolved.
Can we have another court date between now and Christmas, Judge? Is there one?
There's one next Thursday.
Could we have that court date, possible resolution on the case? Is that okay? Would you? Okay.
To do a plea?
Okay.
Is that what you're asking, Mr. Catalanic, your dispositional hearing?
I would love to have that.
Madam Clerk?
That's fine, Your Honor.
We've got 9 AM only.
The 23rd? That's
No,
fine.
no, no, 18.
The 18th is fine.
Yeah, 18.
Yes, sir.
Okay.
12/18 is fine.
All right, we'll
9
set it
a.m.
for change of plea on the 18th.
Yes, sir. Judge, thank you for your time. That's all I
Thank you,
have,
now.
sir.
Good day.
See you right now.
I thought I saw Mr. Nopes. Let me know when you're ready. I see you working your cases. Just let me know when you're ready, okay? All right.
Yeah. I'm gonna address my people. I'm
Say
gonna address
again?
my people in the gallery first, Your
Sure,
Honor.
sure. Charles?
Charles, I'm gonna take care of my people in the gallery. All right.
Let's clear the courtroom first. Go ahead, Mr. Cochran.
All right.
Call your cases.
Yes, Your Honor. Mr. Tyler Lunsford, Your Honor. This is case number 23 CF 1438. Your Honor, Mr. Lunsford needs a little extra time to finish his community service hours. I'd ask that we set this on January 15th.
Any objection?
No objection, Your Honor.
All right. 1:15 for status. And at
1:15,
9
get
o'clock,
your stuff
good?
done. Yes, Your Honor, that's good. Thank you, sir. Get your stuff done and we're good.
And if you get it done earlier, get the documents to Mr. Cochran, who will share them with the state, and you might not need to come back on the 15th, okay?
Sounds good to me. Thank you.
All right,
Ms. Mearns, Your Honor, Mara Mearns, 23 CF 1805.
all right. Ms. Mearns?
She has 3 days because of the holidays. She has 3 weeks. Once, she's seen once a week. Yeah.
Just get me approved, same thing, give me proof that you can do treatment.
Yes, Your Honor. Ms. Mara Mearns, 23 CF 1805. Your Honor, she has 3 more treatment appointments. So
Okay.
we asked to set this for January 15th.
1:15 at 9 o'clock for status, and once again, if you get that done, share it with your lawyer, or give it to the state, and you might not need to be back, okay?
Yes, sir.
All right, thank you now.
January 15th. Your Honor, I have Mr. Ryan Martin. This is 23 CF 0543. Your Honor, at this time, my client has completed DUI school.
Your Honor, based on the completion of the original DUI requirements, we would announce a dismissal of this violation of probation and terminate probation as well, Your Honor.
Okay, so the VOP is dismissed, and he's reached his termination date, is that it?
We're going to go ahead and terminate, Your Honor.
Okay. Now, are there any outstanding fees or costs, probation?
Do you have any outstanding costs to probation?
Just court costs, I think, too, for probation.
Okay. Your Honor, my client believes he has about 200 left for probation and his court cost.
All right, so how much time do you, the reason I ask that question is because if it terminates you now, then they're going to report the unpaid amounts, and that may have consequences for you otherwise. So how much time do you need to get those things paid?
Just about a month.
6 months, Your Honor. I'd ask for at least 6 months, Your Honor.
Okay, 6 months to pay outstanding costs.
All right. All right, and if you need more time after that, write the judge beforehand, and he can give you more time.
Okay? All right, thank you very much. Thanks for working hard to get that squared away and take care of business. Good day.
All right. And then, Your Honor, I have there's a Miss Valerie Norris, 23 CF 1474.
Norris?
Norris, Norris.
Right.
I haven't been appointed, and I'd asked to be appeared by, as a friend of the court, because I believe this may be resolved. She had to pay some fees, and she paid the last $90 yesterday.
State?
Do we have a case number? I don't even know.
Yeah,
23 CF 1474.
he got added late. Madam Clerk, does it show that it's been paid?
I'm showing a 0 balance payment was done yesterday for court costs.
Your Honor, at this time, we would announce a dismissal of the VOP and terminate probation in 23 CF 1474.
What's that?
And there's no outstanding costs.
Correct.
All right, very good. Thank you now. Good day.
Thank you. You as well?
Okay. I believe that's it for what I have in the gallery. I'm ready to start with, no, I'm ready to start with.
Well, let's see if we can move the rest
Okay.
of the folks out of the gallery so we can take care of them and let them get about their business.
Okay.
Folks in the other room aren't free to do that.
I'm not sure. Do you have any? Did you have your case number? Did you have your case number? No. Your Honor, I have Ms. Mr. McLeod in front of us.
Say again?
Mr. McLeod?
McLeod?
Yes, Your Honor. I don't see him on my written docket.
He's not, he's pro se technically, from what I can gather.
William Bradley McLeod?
Yes, sir.
Okay. And this was here for status, and I show that was if all conditions but payment, then a termination with 24 months to pay was what we were at, right?
Yes, that was what I recalled. Do we have, do you have?
Yeah, I mean, I guess.
Your Honor, I'm in receipt of the certificate for the completion of the community service work, the victim impact panel, as well as the UI school from Bridgeway. Given this, we would announce the dismissal of the DFP and terminate probation.
All right. And all your outstanding costs, you'll have 24 months to pay. All right? Thank you very much.
Thank you, sir.
All right, we still have a couple other folks in the gallery. Let's see who they are. Let's get them moved on. And what's your name?
Diane Wiley.
Whaley?
Wiley.
Wiley.
W-Y-L-I-E.
All right. Because we were here, there was confusion about your notice, and we reset you for today. You're here today without a lawyer. You're entitled to the appointment of a lawyer at the state's expense if you cannot afford a lawyer. Would you like to hear what the state offers to resolve this violation of probation before you make a decision on whether you want a lawyer or not?
Yes, please.
All right, what's the state's offer on to dispose of this?
Your Honor, with the violation, the score sheet would be 32.4 total sentencing points. The recommendation would be to modify probation extended for a year past 8/13/26. Apply to have an evaluation for Keaton, and if eligible, complete Keaton and any aftercare, and when she would graduate or complete that program, or she'd have a curfew from 7 to 7 for the duration of her probation. And all original terms and conditions would be reimposed, Your Honor. And if that was not something she wanted to take, the alternate would be 11 months, 29 days in the county jail.
All right, you've heard the state's offer. Do you want a lawyer to help you?
Yes, please.
Okay, can you afford one on your own?
No. Do I have an option to get a public defender?
Yes, ma'am. And
Okay.
what I'll do is give you the form to fill out right now. If you'll sit back down, fill that out, and give it back to a bailiff. Don't leave until you turn the form in and get a new court date, okay?
Okay.
All right?
All right, thank you so much.
All right, thank you.
Mr. Notes has one in the gallery, but I don't see him in the courtroom right now.
All right, so let's start with our folks in detention then. Charles.
Desiree Lige with Mr. Cocker.
Your Honor, this is going to be a plea this morning. I'm just waiting for a signature from the state and from my client.
Yes, sir.
She's mine.
Yeah, this is.
I left it blank, so we can write it up here.
To put their names here.
And sign and date.
Your Honor, in the terms, this is Ms. Desiree Lige, 22 CF 0450. Today, my client is going to admit the violation. It'll be an adjudication of guilt. Adjudication of guilt, modify probation with original conditions, and add a requirement to successfully complete Lakeview program. Defendant will be released to her mother or grandmother and report to Lakeview intake at 1315 Westlake Avenue, Pensacola, within 24 hours, plus cost prosecution and cost of defense. I'm gonna have my client write in, or give me her mother and grandmother's name, so I can put that on the form, and then I will give it to you, Your Honor.
All right.
What's your mother's name?
Jacqueline,
Jack.
Quulline.
Q-U-L-I-E-N. Last name?
Ine.
Last name?
Marge,
Okay, and your grandmother's name?
Tanya, Toya, Jackson, Jacka.
Okay. Your Honor, if I may approach, I have the signed form and the score sheet.
You may.
And this would be a downward.
Uncoerced negotiated plea.
Yes, Your Honor.
Yes, Judge.
All right, raise your right hand, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
Okay, you put your hand down. You heard what Mr. Cochran said on your behalf and signed the written plea form.
Yes, sir.
You understand by this plea arrangement that you're admitting the violation?
Yes, sir.
And that says to me, Judge, I violated just the way that affidavit report my officer file says I did.
Yes, sir.
Do you understand by doing this, you're waiving your right to a hearing where the state would have to prove that you violated?
Yes, sir.
And in this case, I believe you've already been adjudicated guilty, or is this a new adjudication?
I believe it's previously been adjudicated, Your Honor.
Okay.
Yes.
All right, and you're modifying your, agreeing to modify your probation with the original terms and conditions to be reimposed, and to add the requirement that you're going to enter the Lakeview program, and that you agree that your grandmother or your mother will take you there within 24 hours of your release.
Yes.
Plus, you're going to have an additional $100 cost of prosecution and $150 state-provided legal assistance. Is that what you understood?
Yes, sir.
Mr. Cochran answered all your questions about the plea and how it affects you?
Yes, sir.
You're satisfied with what he's done for you?
Yes, sir.
The court will find the plea to be freely and voluntarily entered into and will accept the plea. Thank you.
Your Honor, I would ask, my client has been in custody for a very long time, and she's going to inpatient treatment. I would ask that any cost supervision and any arrears be waived, and for any cost that can be converted to community service hours.
I'll authorize community service hours for the costs, and I'll waive the cost of supervision and outstanding arrears of supervision for 90 days, until 90 days after her release, or when she obtains gainful employment, whichever is sooner.
Thank you, Your Honor.
Okay?
All right, you understand?
That means that there's no cost of supervision until 90 days after you're released, or when you get a job, whichever's first.
Okay.
All right?
Okay. It was something else.
Okay. All right.
Okay, thank you.
You're welcome. Your Honor, this will also be a plea. If I just have a moment to have my client sign.
Sign and date.
Your Honor, this is going to be a plea, Ms. Joanna Miller, case number 25 CF 0737, Today, Ms. Miller will admit the violation. She will maintain her withhold. We're going to reinstate and modify her probation with all original conditions and add an additional 48 hours of community service. If I may approach, Your Honor, I have the signed plea form and the score sheet.
You may. All right, raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
All right, you can put your hand down. You heard what Mr. Cochran said on your behalf, and you signed the written plea form?
Yes, sir.
Do you understand by this plea arrangement that you're admitting the violation?
Yes, sir.
And that tells me, Judge, I violated my probation just the way the affidavit report my officer filed says I did.
I violated my.
You can just say yes, that's
Sorry.
okay.
Yes.
Sorry
Yes, sir.
about that. And do you understand by making this plea, you're waiving your right to a hearing where the state would have to prove that you did violate?
Yes, sir.
And in this case, adjudication will continue to be withheld. You're going to modify your probation to reimpose all the original conditions plus an additional 48 hours community service, $100 cost of prosecution, $150 state-provided legal assistance. Is that what you understood?
Yes, sir.
And has Mr. Cochran answered all your questions about the plea and how it affects you?
Yes, sir.
You satisfied what he's done for you?
Yes.
Court will find the plea to be freely and voluntarily entered into and will accept the plea. Thank you.
Okay, thank you very much.
Thank you.
So again?
This is a bond hearing?
Hold on. New cases.
Yes, I just got are the new cases being addressed?
What new case?
I don't know, I just,
No, she had a,
Oh, that's in a different
that's in a different county.
it's a different county,
Yeah.
okay.
Yeah, it's a traffic case.
Trenton Lindsay.
If I have one moment, Your Honor. Yes, Your Honor. Today, we have Mr. Trenton Lindsay for a bond hearing. If I may take some testimony from my client.
Raise your right hand, please. You swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
All right. You can put your hand down.
All right, Mr. Lindsay, if you're released on bond, do you have a place to live?
Yes, sir.
And what would that be, address be?
104. We got,
Got the street name. What city is it in?
Fort Long Beach, Florida.
Okay, and who would you be living with?
My sister,
You speak up.
my sister,
Your sister?
yeah,
Okay. Are you employed,
what that mean?
or do you have a job?
Yeah, part-time.
Say again?
I was catching up with where the cases was last week.
Yes.
The state and I have actually reached a stipulated bond.
All right.
Your Honor,
Announce the conditions.
Yes, Your Honor. On count one, it would be a $1,000 bond. Counts 2, 3 would be an ROR.
Counts 2 and 3.
That's correct.
And I believe that is all of the charges. Your docket shows a
Madam Clerk, is that what you show?
I'm double checking, I'm reflecting
You only
four. but
Your, Madam Clerk's reflecting 4 counts.
I'm checking,
Information only reflects 3.
okay, that's what I was checking.
Okay. All right, so count one is 1,000 cash for professional, counts 2 and 3 are ROR?
Yes, Your Honor.
Okay. Any conditions?
No condition. No conditions, Your Honor.
All right, very good. Thank you now.
Thank you, Your Honor.
Who's going to provide the order?
I'll type one up, Your Honor.
All right, thank you.
And I'll have it before we leave the court.
This will be Jaden Lovett.
Your Honor, we have Mr. Jaden Lovett. He has 3 cases before the court. 2020 CF 2867, 2020 CF 2869, and 2020 CF 2870. Your Honor, at this time, I'm going to ask to continue this. My client has a more serious charge here in Escambia, and he also has a charge out of Mariana that I would like to see how we.
Because he was in Jackson County, right? And we brought him here,
Yes, because of,
but he needs to go to Escambia County as well.
The charge is here. So, Your Honor, he has an open 2021 case that we intend on taking to trial and either resolving one way or another.
2021?
Yes.
Because I only have 20 CF cases.
So this is why I think it's crazy. He pled on these 20 CF cases after the 21 case had been opened.
Okay, let's have a case number, so Madam Clerk has good minutes, and I got good notes.
I'm gonna have to look it up. I think it's. It is 21 CF 206, Your Honor.
206.
That is the open, quote-unquote, newer or actual non-probation case, new law, quote-unquote case. That case, he had gotten, and then he had pled these charges out after. So then he allegedly committed a new law violation in Jackson County. He was over there in Jackson County, they transported him over here to handle these VOPs, but we also have
The 21
the
case.
21 case. The intent, I believe, that Mr. Nopes is his attorney on the 21 case.
Ms. Nopes, you're on 21?
I am, Your Honor.
Okay.
I think the intent of Mr. Nopes and I is to resolve that case one way or another in the first cycle, or in January cycle, the first cycle of 2026. From what I understand, speaking with Mr. Cochran, the defendant feels as though he has defense to the new law violation over in Jackson County, but he won't be sent back over there. I was actually in Jackson County the day that he showed up there for his arraignment. They sent him over here because I said, we have this new case, we have a trial that we've been trying to get done, it's a 21 case. So they sent him over here for us to resolve that case. After that case gets done, he's likely gonna go back to Jackson County to try to resolve a new law case, which would affect his VOP. According to him, he has a defense of standing your ground, if I'm not mistaken, on the Jackson County case. That is the puzzle which we are working in.
All right, because I don't see the 21 case set. Do you see it set, Madam Clerk?
No, Your Honor, it has not been set since.
8:25, 8:15, right?
Correct.
That was because he, if I'm not mistaken,
He was in Jackson County,
in Jackson County.
right? And my notes indicate that there was some confusion about a witness or something, right, Mr. Nopes? Is that my memory right about that?
Judge, that was at that time, and we were able to take his deposition at the Okaloosa County Jail. I don't have that file, so I can't give you dates, but that's been resolved.
Right, that's what my notes show, that you, after a lot of massaging, I'll just put it that way, you were able to get that depot. So if we set this for the January pretrial cycle, Mr. Nopes, will that?
What is the date of that, Judge?
It'd be the 12th, yes. And since he's incarcerated, he'd actually be here on the 14th. But the trial cycle's the 12th, docket day's the 20th, and then trial week is the 26th.
Judge,
Granted. Good fortune you were here, Mr. Nopes. Help us twist this pretzel into place.
All things meant for a reason.
All right, so what we'll do is we're going to set the 21 CF 206 case on the January cycle. The VOPs will travel with it. If there's a resolution, it can be advanced on any time that I'm here.
Thank you, Your Honor.
Okay? All right, very good. And I've, okay, Stephen Martin. Gotta be careful because we got Martin.
Your Honor, we have Mr. Steve Martin, 24 CF 2474. I'd ask that that we hold him for a little bit. It's going to be a plea. I just need to type it up.
Okay, so you need to chat with him?
No, we've already talked this morning. I just need to type up the actual
Okay,
terms.
all right, very good. If we'll hold Mr. Martin for a plea, please. Say-
Yeah, you're going to be back today.
Okay. Thank you.
And we've got Madam Interpreter here. Do we want to see if we can queue up the cases that we need her for so that we can take care of them and get her on to her other court business?
That'd be great, yeah. I've got one.
I don't have any.
You don't?
I have a 1:30.
Say again?
Sorry, Judge. I have a 1:30. I don't know if they're present yet.
Well, if they are, yeah, call them. No reason to wait. No, she's one of the busiest people in the courthouse. Let's use her most efficiently.
Your Honor, while we're waiting for them to get the last, or Mr. Noakes person, can I do my last in custody? Or?
Yes.
Your Honor, this is also going to be a plea. Just need a moment for my client to sign.
Sign and date. It's the, okay, 90 days. Okay? No, it's still your misdemeanor. So sign and date.
Your Honor, at this time, Mr. Micah Moore is before the court on case number 24 CF 1995. Your Honor, today my client is going to admit the violation. It will be an adjudication of guilt. It was previously withheld. It'll be a term and revoke, 90 days, Okaloosa County, cost of prosecution, cost of defense.
12, 11.
If I may approach, Your Honor, with the sign form. This
Granted.
was previously reduced to a misdemeanor, so there's no score sheet. Your
All
Honor.
right. All right. Mr. Moore, if you'd raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
All right. You can put your hand down. Now, you heard what Mr. Cochran said, and you signed the written plea form.
Yes, sir.
Do you understand by this plea arrangement that you're admitting the violation?
Yes.
And that says to me that you agree that you violated just the way the affidavit and report says you did.
Yes.
Do you understand by doing this, you're waiving a right to a hearing where the state would have to prove that you did violate?
Yes.
And in this case, you'll be adjudicated guilty if not previously. Your probation will be revoked and terminated. You're going to be sentenced to 90 days in the county jail. And you'll have an additional $100 cost of prosecution and a $150 state-provided legal assistance. And you'll have whatever your outstanding costs are. How much time you'll need to get those paid after your release?
A year. Close, to probably a year.
A year to pay. And I didn't hear, credit for time served?
Yes,
or-
Your Honor, I was just about to say.
All right. Credit for time served. Mr. Cochran, answer all your questions about the plea and how it affects you?
Yes, sir.
Satisfy what he's done for you?
Yes, sir.
Court will find the plea to be freely and voluntarily entered into and accept the plea. Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
Next will be Anita Lima with Mr. Hooks.
And Madam Interpreter, if you'd raise your right hand, do you swear to interpret these proceedings truthfully, adding nothing and subtracting nothing? Mr. Nopes, do you need a moment with your client?
I just need you to sign this, Judge.
Okay. If you'd raise your right hand, please, sir. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
I swear.
All right. Mr. Nopes, if you want to proceed.
Judge, this is Eli Pinedo Lima.
You can put your hand
And the case number is 25 CF 291. Count 1 is shooting into or within an occupied vehicle, second-degree felony, maximum of 15 years, $10,000 fine. Count 2, aggravated assault by threat with a deadly weapon, third-degree felony, 5 years, $5,000 fine. Count 3 is carrying a concealed weapon, third-degree felony, maximum penalty 5 years and $5,000 fine. Judge, he's going to enter a no contest plea as charged with the understanding that he'd be adjudicated guilty. He'd be sentenced to 23.7 months, Department of Corrections, with credit for all time served. This sentence is going to run concurrent with his Florida Northern District Court federal case. That case number is 3:25-MJ-00039. In addition to that, Judge, this sentence, Department of Corrections sentence will be coterminous with this federal case as well. He'd have $5.15 in court cost and a $150 court-appointed legal assistance fee.
With the assistance of the interpreter, were you able to read and understand the plea form?
Yes.
And is what Mr. Nopes just announced what you read in the plea form?
Yes.
How old are you?
20.
And how much education do you have?
10th grade.
Do you understand by this plea arrangement that you're pleading no contest to the announced charges?
Yes.
And that says to me that you believe the state has the evidence necessary to prove your guilt to the jury, and you're not going to contest that.
Yes.
Do you understand by making this plea, you're waiving your right to a trial by jury where the state would have to prove your guilt?
Yes.
In this case, the penalty imposed by the plea agreement is an adjudication of guilt and 23.7 months in the Department of Corrections with credit for all time served to run concurrent with your federal case.
Okay.
In addition, you'll have some fees and costs which will be due. Has Mr. Nopes answered all your questions about the plea and how it affects you?
Yes.
Are you satisfied with how he's represented you?
Yes.
The court will find the plea to be freely and voluntarily entered into and will accept the plea.
Judge, did you announce that it's coterminous with the federal case as well?
No, I did not. It will be concurrent and coterminous with his federal case.
Thank you, Judge.
Thank you, Mr. Nopes. A year.
Take that. Thank you. Judge, I do have other cases, but do you want me to wait?
Yeah, let's see if we can use the interpreter most efficiently, okay?
Judge, my 130, I believe he's in ICE custody, so I don't anticipate needing the interpreter today.
And who is that?
Judge, it's last name Saavedra Vasquez.
Okay, so you believe they're in ICE custody?
That's correct. And that's 25 CF 2093.
Okay. All right, so no further need for the interpreter from y'all's point of view. Anybody else? Okay. All right, thank you very much, Madam Interpreter. We'll wait at 1:30 and see what happens.
Yes.
Judge, may I call two out of custody?
Yes.
Lisa Thornton?
And did we get the application from the web?
And Madam Clerk, I'm also going to be calling a Matthew Warner, who's on the 130 docket after Ms. Thornton.
Thank you.
Judge, we had set Ms. Thornton in 25 CF 8 over for a restitution status, because this is in a pay and dismiss type situation.
Yes, sir.
She made a payment today in the amount of $200. That's going to leave a balance of about, I think, $300. Is that correct? Judge, she is applying everything she can towards this. I'd ask for this to be placed on the January miscellaneous date to bring this in for a landing.
All right, 1:15 at 9 o'clock. Now, and if you get that taken care of before then, get those receipts to your lawyer who will share them with the state, and you may not need to be back, okay?
Okay, 1:15.
9 o'clock.
You get it done ahead of time, though, and then let me know. as we see. Okay? Thank you, Judge. I also have Matthew Warner, who's present in the courtroom. He is on the arraignment docket at 1:30. He's been here since 9 o'clock in 25 CF 2230. We would acknowledge the receipt of the information. I
Hold on a
reviewed it
second, let
yesterday.
Madam Clerk get up with you. You good? All right, go ahead, Mr. McKinney.
We would waive formal reading and enter a plea of not guilty, and ask for this to remain on the next available pretrial.
Do you know when we're set, Madam Clerk?
We're set for January 12th, and here's a copy of his information.
All right, we'll remain set for January 12th. Stay in touch with your lawyer, be back on January 12th unless he gives you instructions otherwise, okay?
Yes, sir.
All right, thank you.
Make an appointment to come see.
And Diane Wiley, please. All right, Ms. Wiley, it looks like you do qualify, and I'll appoint the public defender. The clerk will review this. If they think you don't qualify, they'll tell you why. If you think they're wrong, get everything you have that shows the clerk is wrong, give it to your lawyer, and bring it with you to court next time so that we can review it, okay?
Okay.
All right? Mr.
Judge, we'll enter
McKinney.
a denial to the violation of probation and ask for the next available miscellaneous date, not next week, but the first one we have in January.
Okay. Madam Clerk, that would be the 15th?
Yes, Your Honor.
And Judge, I'd ask for that to be set without subpoenas.
Okay. Denial without subs on 115. You heard the offer, Mr. McKinney? Would you like?
Yes,
me to-
I did.
Okay.
Thank you.
Thank you, Judge.
Thank you. Stay in touch with your lawyer and be back on the 15th, okay?
Yes, sir.
Thank you now.
Judge, if I may call one that's in the gallery?
Yes.
Miss Sells, first name Laura. Miss Laura Sells in 25 CF 1101, Your Honor.
Yes.
Judge, we're here for a violation of probation. Speaking with Mr. Snell, the current offer is 26.25 months, Department of Corrections. I'd like to enter denial and set this with subpoenas. I heard that 115 date. Is there possibly another January date?
22.
Could I get the 122 with subpoenas?
All right, 122 with subs. We're setting those at 2 o'clock now, right, Madam Clerk?
Yes, Your Honor.
122 at 2 o'clock with subs.
2 o'clock.
All right. Now, Ms. Sells, that essentially means it's set for trial on that date. So you need to be in touch with your lawyer. He's got to have contact with you to help be prepared for the trial, okay?
Yes, sir.
All right, thank you now. Good day.
That's our next court date, but call today.
I will.
Schedule a topic.
Thank you.
Yes. And that's all I had present in the gallery.
Anybody else in the gallery?
Judge, I've got one in the gallery.
Okay, come on, Mr. Nopes.
Judge, I've got Ms. Youngblood.
Yes, Ms. Youngblood.
Is Jamaica Youngblood, 23 CF 2552. Judge, we have a, guess it's a PTI that we signed and gave to probation. Thank you. I'm sorry? Get approach.
Granted. All right. So we'll set, so it's all squared away, it's all signed by everybody, right?
Yes, sir.
All right. Thank you very much.
Judge, other than that, the only difference between what probation saw is that the state and I agreed to waive the cost of supervision, and you allowed that.
Right.
Okay. So they got their records right. Thank you, Judge.
Thank you.
Thank you.
Okay. Why don't we take Mr. Ship then? Judge, this is Mr. Ship's case, 25 CF 2011. Judge, he was arrested, and basically, I think he's been in jail since the time of his arrest. He did not make first appearance October 3rd of 25. He did not make first appearance, and he was ill, so he didn't ever really get a chance. He was just denied bond when he didn't make first appearance. He was ill, that's what his testimony would be. But he tells me that he's never failed to appear. He's lived here for 42 years, all of his life. His whole family, sisters, mothers, families, et cetera, live here. And he's got a job with Professional Tree Service and one other tree service that he also works with on the side. And we'd ask the court to consider giving him a reasonable bond. I think that the burglary of an unoccupied dwelling, unarmed assault, no battery. So it's a second-degree felony. Judge, he doesn't have a lot of money, but he understands that if the court sets a bond, that he would have to somehow, some way come up with the money, but he can't afford a very large bond. So I would ask the court to consider giving him a $1,500 bond on one, and then on the other third-degree felony, giving him say, a $1,000 bond on it.
Okay, so the refusal was because he was ill at the jail and didn't come?
That's correct.
Okay. All right. What's the state's position on an appropriate bond?
Well, given whether we have a burglary to a dwelling, I believe no bond is appropriate, Your Honor. If I could have just a moment to pull this case.
I think he's entitled to bond. The only reason no bond was given is because the court understood he refused to appear at first appearance. And so, as you're aware, that I can't, if there's nobody there, I can't. And I actually did that one. So, yeah, so that's my approach, because then counsel has the opportunity to file the bond motion. We're here. So, absent a pretrial detention motion, I don't believe I can just no bond somebody.
I would recommend, Your Honor, $50,000.
Although I know some.
Excuse me.
Go ahead.
I just talked over you. I didn't mean to. So
That's okay. Go ahead.
$50,000 cash for professional, count one, and 5,000 cash for professional on count two, the state's recommendation.
And Judge, the only thing I can say is that's in essence a no bond for this gentleman.
Well, he's got 25 CF 693, right? As well, is he, what's the status of that? 25 CF.
What's that case number, Judge?
It's 25 CF 693.
Judge, I was not aware of that.
Those are all closed cases. They've reopened them because it's a new charge.
So did you have a
I think he pled to that. I don't know what the disposition of that was.
It was a lesser included offense for petty theft and credit for time served. And I was released. And I had no probation or anything like that.
Right. He got 140 days, lesser included petty theft, 140 days. And then he had a VOP on a misdemeanor, which was pled at the same time. So that case should be disposed of.
Yes, sir.
Right, time is expired on that at this point,
That-
because that plea was back in July. So, and so I like to be sure that everything's squared away, so.
Absolutely.
So, to resolve the case, Your Honor, on the 2011 case, the state's offer to resolve it is 60 months state prison. The score sheet totals 84.7 points for 42.522 minimum lowest permissible prison sentence.
42 point,
525, Your Honor.
okay.
Judge, I'll be setting depositions here soon. So I can figure out what's going on with the case, but he's not today in a position that he could accept that offer. And it's Christmas time.
All right, so what's the state's offer on the bond? What did the state agree? Count one, what?
50,000 on count one, 5,000 on count two.
All right. Where will the defendant be living if the defendant makes bond?
Shalimar,
Give him the address.
91 Country Club Road, Shalimar, Florida.
And who else lives there?
My mother and my father, Kay and Jeff Ship.
So that's their house, then you live there?
Yes, sir.
All right.
They're allowing me to stay there until I can get my apartment correctly in. But since I've been incarcerated, I haven't been able to make the payments.
Well, this is the court's concern. I've read the addendum probable cause, and I've looked at also the first appearance paperwork. In this case, 2 prior violent misdemeanors, 18 prior felonies. And the addendum of probable cause includes, post Miranda, the defendant admitted
Yes, sir.
the crime involved, which was a person's dwelling house. Now, it was unoccupied at the time. However, based upon those circumstances, and if you reviewed the first appearance paperwork, I had initially set the bond on count 1 at $100,000, and on count 2, I had set the bond at $50,000, and then changed that when there was a refusal. So The court will accept the state's recommendation. It'll be $50,000 count one, $5,000 count two, no contact with the victim, and pretrial services standard conditions with weekly reporting.
Yes, sir. Who's next? Oh, that's you.
And after this, we'll take a comfort break.
Yeah, I've got two more, Judge, but that's all right.
Judge, this is Ms. Naomi Perez, 24 CF 910. If I may have a brief moment for a signature. Judge, Ms. Perez will be admitted to the violation. The terms of the plea agreement is maintain the withhold. We're going to modify the remainder of probation to be converted to drug offender probation. This has that curfew from 7 p.m. to 7 a.m., may be adjusted for work or school purposes. The $40 per month cost supervision, the $100 VOP cost prosecution, there's $150 defense costs. There's also $515. It's the original outstanding court costs from the original plea agreement. No drugs without a valid prescription and random UAs. If I may approach with a signed plea form and score sheet, Judge.
Granted. Raise your right hand, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, Your Honor.
All right, you can put your hand down. You heard what Mr. Koch said, and you signed the written plea form.
Yes, Your Honor.
Do you understand that by this plea arrangement that you're admitting the violation?
Yes, Your Honor.
And that says to me that you agree that you violated your probation just the way the affidavit report filed by your probation officer says you did.
Yes, Your Honor.
You understand by doing this, you're waiving your right to a hearing where the state would have to prove that you violated.
Yes, Your Honor.
In this case, adjudication will continue to be withheld. The remainder of your probation will be converted to drug offender probation with a curfew that was announced, can be adjusted for work or school purposes with a cost of supervision. The additional $100 cost of prosecution and $150 cost of state-provided legal assistance, plus the conditions with the no substances and the random testing to confirm that. Is that what you understood?
Yes, Your Honor.
Mr. Koch answered all your questions about the plea and how it affects you.
Yes, Your Honor.
Satisfied with what he's done for you.
Yes, Your Honor.
Find the plea to be freely and voluntarily entered into and accept the plea.
Yes, Your Honor.
Thank you, Judge.
Thank you, Your Honor.
All right, thank you. And we'll take 10 minutes at this time.
Thank you.
You'll talk to probation.
10 minutes.
All rise.
2255, that new law information has been filed. That is set for the 18th. I'm asking if we can enter a not guilty, waive formal reading, if we can keep both cases on that 1/12 pretrial date. And I told my client that if we get that Keaton acceptance letter sooner, I can advance her on the docket.
All right. So ordered.
Thank you, Judge.
You got that, all of them together?
Yes, thank you.
Mm-hmm.
Judge, this is Mr. Timothy, last name Smith, in 23 CF 2161. If I may also add a misdemeanor case number, it's 25 MM 2659, and that was 25 MM 2659. If I have a brief moment for a signature, Your Honor. Judge, Mr. Smith, in the 23 CF 2161, this will be an admission to the violation of probation. Adjudication of guilt, 12.1 months, Department of Corrections. Credit for all time served. And there's the $100 VOP cost of prosecution, $150 in defense costs. Revoke and terminate probation. In the 25 MM 2659, the adjudication of guilt, credit for time served, 270 in court costs, 100 in defense costs, all cases and counts to run concurrent. If I may approach with a signed plea form.
So, Your Honor, the score sheet amounts to 43.2 total sentence points, and I'm going to email it to Mr. Koch, and we'll print it and hand it in to you in just a moment.
All right, raise your right hand, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury? Okay, you can put your hand down. You heard what Mr. Koch said on your behalf, and you signed the written plea form.
Yes, sir.
How old are you?
I am 46.
All right, so we got two things going on today. You got your new charge on the misdemeanor, and you got your VOP.
Yes, sir.
Okay, we're taking care of them together, but they're two different things, right?
Yes, sir.
As to your misdemeanor, you understand that you're pleading no contest and waiving your right to a trial by jury.
Yes, sir.
You'll be adjudicated guilty, sentenced to time served, have the fees and costs that were announced.
Yes, sir.
As to your violation, do you understand you're admitting the violation?
Yes, sir.
And that says to me that you violated your probation just the way the affidavit report says you did.
Yes, sir.
Do you understand by doing this, you're waiving your right to a hearing where the state would have to prove that you violated?
Yes, sir.
All right, you're going to be adjudicated guilty on the felony case. And since the 12.1 months Department of Corrections, credit for all time served, you'll have an additional $100 cost of prosecution, $150 state-provided legal expenses. Your probation will be revoked and terminated. How much time will you need to get everything paid up after you get out?
No more.
24 months, okay?
Yeah, that's plenty. Yes, sir.
All right. Mr. Koch answered all your questions about the plea and how it affects you.
Yes, sir.
You satisfied what he's done for you?
More than satisfied. Yes, sir.
The court will find the plea is freely and voluntarily entered into and accept the plea. Thank you.
All right, that's the one, Mr. Smith. You're welcome. You're welcome. Judge Britton Snell, this is 21 CF 2826. Thank you, Judge. We're here for a violation of probation, Your Honor. We're going to be entering a denial this morning. Current offer, Judge, speaking with Mr. Snell, is 40 months, Department of Corrections. So I'm requesting that we set this on the 122 docket with subpoenas, Your Honor.
122 with subs.
With subs, Judge. Thank you.
All right, very good, thanks.
Next is Daniel Solis.
That's the living penalty right out of jail. Yes. Thank you. Daniel Solis in 24 CF 426, Your Honor. If I may have a brief moment just for a signature. Judge, this morning, we will be admitting to the violation. My client was previously, this was a withheld, but this will be an adjudication of guilt. It's 12.6 months Department of Correction, credit for time served. There's the $100 cost of prosecution, $150 defense cost, and probation will be revoked and terminated. If I may approach with the signed plea form and score sheet.
Raise your right hand, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, Your Honor.
Okay, and you can put your hand down. You heard what Mr. Koch said. You signed the written plea form?
Yes, Your Honor.
All right. Do you understand by this plea arrangement that you're admitting the violation?
Yes, Your Honor.
And that says to me that you agree that you violated your probation just the way the affidavit of your probation officer says you did.
Yes, Your Honor.
Well, you're hesitating. Do you not agree that you violated?
That's, yes, Your Honor. You said, I agree, yes.
Okay. Do you understand that by making this plea, you're waiving your right to a hearing where the state would have to prove your violation?
Yes, Your Honor.
In this case, you'll be adjudicated guilty if you weren't previously, and you'll be sentenced to 12.6 months in the Department of Corrections, credit for all time served, $100 cost of prosecution, $150 state-provided legal assistance. Your probation will be revoked and terminated. I'll give you 24 months to pay after you're released. Okay?
Thank you. Thank you.
Thank you now. Good day.
This is Matthew Strong.
Judge, this is Mr. Matthew Strunk. This is 23 CF 2795. Yes, Judge. Judge, we're here for a violation of probation. We'll be entering a denial this morning. I did receive confirmation this morning that Master's Touch, the faith-based treatment program, my client successfully completed the program, but of course we have these violations in front of us. They are willing to accept him back in the program. So I did explain this to Mr. Snell. I'm asking if we can put him, if possible, on next Thursday's docket, because my intention is to show that paperwork to Mr. Snell and get my client back on probation. Yep. That's why I'm trying to get you on next week's docket.
All right, reset for the 18th, Mr. Snell.
Willing to review it?
All right, for possible plea.
Yes, sir.
All right, we'll see you on the 18th at 9 o'clock.
Excellent. Yep, and I'll see you probably at the jail. Yes, okay.
Next would be Julian Lodello. Lodello.
Now, I show that as was Smith Jaquith, but are you,
It's mine, Your Honor,
okay.
at this point. Lobella, it's still in my system. No, it's the, this is the one that came back, no drugs.
And counsel, if you'll approach.
Your Honor, this time we would announce a null cross of 25 CF 1852, and then a dismissal of the VOP in 22 CF 3007, and reinstate to complete the original terms of probation.
All right, say again the case number, 25 CF
1852.
1852, the state announces a null
And
pros.
just for the court's record, the FDLE report came back as no controlled substances. So
Okay.
it's clear. And then, because that case is null pros, that was the basis of the VOP is now gone, so we would dismiss the VOP and reinstate to complete the original requirements of probation.
Okay. All right, so the case is null pros, the VOP is dismissed, reinstate to complete original terms and conditions.
Thank you, Your Honor.
All right.
Thank you, Your Honor.
Judge, this is Jacqueline Thompson before the court. She's here in two case numbers, 25 CF 1764 and 25 CF 1765. These are new cases, they're not violations of probation. She was placed on the mental health court docket, so she didn't make pretrial with us. Mental health court is not going to be an option, so she was placed back on our docket, which is how it ended up on today's docket. So we're just going to request for this to remain on the January pretrial court date. We already have depositions that are scheduled on the 19th of December.
Right, and I see the state's prior offer was the 60 months Department of Corrections, correct? Has that been any modification since then? Okay, all right. All right, so we'll leave it on for 112 with understanding the depo scheduled and on 12/19.
Correct.
All right, thank you very much.
12/19 is the depots we talked about. I'll come see you after that.
Mr. Tina Warrington, Mr. McKinney.
Judge, this is Ms. Tina Warrington before the court. She's here in 24 CF 2489. We have reached an agreement in this case for Ms. Warrington to make the record redundantly clear. She did go to Florida State Hospital and the court found her competent to proceed. She was placed back on the docket. We have since reached an agreement. The agreement calls for Ms. Warrington to enter a plea to a lesser included offense in count 1 of felony criminal mischief. Counts 2, 3, and 4 would be pled as charged. Count 4, the misdemeanor, would be time served. The 3 felony counts would be a concurrent 12 months state probation. The special conditions of the 12 months probation are that Ms. Warrington will be entering into and successfully completing the Bridgeway 90-day program. Bars to bed placement, she's been approved for that program. And she's looking at placement either tomorrow or Monday. She must follow all rules and conditions of that program, comply with conditions of mental health pretrial services, even though this is a probation plea, take all medications as prescribed. There is $515 in court cost, $150 cost of defense. In this matter, the state has agreed to waive the cost of supervision. This would be with an adjudication of guilt. May I approach with the plea agreement?
Granted. All right, if you'd raise your right hand, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yeah.
Okay, and you put your hand down. You heard what Mr. McKinney said on your behalf, and you signed the written plea form.
Yeah.
And how old are you?
56,
All right, and how much education do you have?
high school diploma.
All right, you able to read and understand the plea form?
Yeah.
Did you do that before you signed it?
Yeah.
And it's what you read in the form, what Mr. McKinney just told me.
Yes.
Okay, do you understand by this plea arrangement that you're pleading no contest to the charges that were announced?
Yeah.
And that tells me you think the state could prove your guilt, and you're not going to contest that.
Yes.
Okay, do you understand by doing this, you're waiving your right to a trial where the state would have to prove your guilt?
Yes.
Okay? And in this case, you'll be adjudicated guilty, and you're going to be on 12 months of probation with the special condition that you go to the Bridgeway 90-day program.
Yes.
And that you'll go from jail directly there, and you've got to follow all their rules and conditions,
Yes.
including the, regarding your, following your medical directions regarding your medications and other circumstances.
Yes.
Okay. Mr. McKinney answered all your questions about the plea and how it affects you?
Yes.
Satisfied what he's done for you?
Yes.
Court will find the plea to be freely and voluntarily entered into and will accept the plea.
Thank you, Judge.
Tracy Rosato.
Okay, that's okay. Okay. Ms. Rosato is here for violation of probation. In 23 CF 457, To include the court in what's going on with Ms. Rosado, we have looked at a number of different options over the last several months for Ms. Rosado. We are engaged with APD in trying to find an appropriate group home setting at this point. We have engaged with all the different sides of APD to try to make that happen. They've requested additional paperwork, which Ms. Rosado has just handed me, for me to provide to APD. I'd like to bring this back next week with all the moving pieces in this. I'd like to try to bring this in for a resolution. The expectation is that once we find Ms. Rosado an appropriate placement where she will have a stable place to live and services, that I believe that the state may be in a position to dismiss the violation of probation, to move forward with a modification and placement. So I'd like to bring this back next week to try to get additional answers from APD to see what our timeline is going to be as far as placement.
All right. Any objection?
No, Judge.
9 o'clock on the 18th?
That's fine, Judge.
Okay, very good. See you then. Thank you.
There's a tablet.
And while he's coming out, if state would approach on Joshua Rogers, please. State and defense.
Judge, this is Joseph Talbot before the court in 25 CF 1067. We're on the docket today for a bond hearing. This should be styled as a second bond hearing. There was a previous bond hearing in June of this year that the court did deny. So I'd like to take some testimony from Mr. Talbot.
Raise your right hand, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
Okay.
Sir, could you please state your name for the record?
Joseph Daniel Talbot.
And obviously, you are unable to make the $500,000 bond that's currently set?
Correct.
And we previously had a bond hearing in June. So can you explain to the court what has changed in your circumstances since the last time that we were in court?
About maybe three, almost 4 weeks ago, my child's mother had passed away in a bad car wreck. Her and her husband got to a bad accident coming back from up north, and it was both killed them, I guess, on the impact. The child's mother was put in ICU and passed away in ICU. And so now I'm trying to get out and find out where my daughter's at. She's 7 years old, and I've only had something to do with her maybe twice. But in the meantime, I was working a case plan to get everything where I can have her back in my custody. But during all this process, this happened, and now, yeah,
If you were released on bond, what would your address be?
5376 Highway 4, Baker, Florida.
Who lives at that address?
My niece Cadence Holford and Jason Colburn and my fiance Ashley Scott and our 2 kids.
Previously, you've told the court that you have been and are self-employed with a cleaning business. Is that currently still the same?
Yes, sir. Yes, sir. With renewing all certification, yes, sir, it's still the same.
Is there anything else you want Judge Stone to know before he makes the decision on whether or not to reduce the amount in bond or not?
Your Honor, I'm begging for this chance, and I promise you I won't mess it up. And I do apologize for being back in your courtroom, but please grant me the opportunity to figure out what's going on with my child.
No further questions.
State?
No questions for the defendant.
What do you think?
All right.
Judge, Mr. Talbot is asking for any relief. We're asking, if the court asks us for a dollar amount, we're asking for $10,000 cash for professional in count 1, ROR in count 2. It's a 2-count information. Count 1 is the trafficking in methamphetamine. Count 2 is a possession of paraphernalia.
State?
Your Honor, the state would object to modification of the bond, believe that it's appropriate in that, frankly, if Mr. Talbot were to be released, I believe that he would continue to distribute narcotics in our area here. He has 40 prior convictions that are all centered around that activity, whether it's thefts and multiple possession convictions. And,
go through this with the
he's got 112.3 sentencing points right now for a total of 63.255 months is the lowest sentence. The 15.85 grams of meth that he had on him when he was arrested calls for a 3-year mandatory minimum sentence and a $50,000 fine. I believe that the bond is appropriate in this situation.
Anything further, Mr. McKay?
No, Your Honor, not at
Yes.
this time. What do you want to challenge the amount of conviction?
Yes,
I wouldn't suggest you do
no, it's
that,
not,
please.
no, the modifications. But, hold on, just one second. Me, if it would be pleasing to the court, I'd be willing to wear a monitor, take a drug test, do what anything y'all need me to do for this bond to be reduced. My child's mother has just passed away, and my 7-year-old daughter don't even know her father's in jail. I'm begging the courts to help me with this. I promise you, the situation I got caught up in.
Well, don't talk about the facts of the case now.
I understand that. I mean,
Don't talk about the facts of the case. You know, Mr. McKinney will tell you, I listen to everybody, I try to make the best decision I can. My problem, Mr. Talbot, is, and I saw you talk to Mr. McKinney about your priors, is according to the information provided, you've got 6 prior violent felonies, 3 prior violent misdemeanors, 20 other prior misdemeanors, and 17 other prior felonies. The case involved here has a 3-year minimum mandatory, plus it would be subject to a pretrial detention motion, and I'm just assuming the state didn't do that because of the bond that was previously set at first appearance. Because this is a trafficking charge, and under the present statute, the legislature said that that the judges are not supposed to set modest bonds in those circumstances unless the state so consents. So your personal situation is just horrible. At the same time, I'm compelled to follow the law, and I don't see circumstances here that really permit me to deviate from what was previously set under the circumstances presented, absent the state's agreement. So the motion is respectfully denied.
Judge, we do have depositions scheduled of all the witnesses on the 19th of December.
Correct. You'd already told me that, and you've got quite a few set that you're trying to do.
Yes, Your Honor. And then I'm going to provide a copy of the score sheet that's been provided to Mr. Talbot. So I'd like the record to reflect that.
All
So
right.
he has a copy of the score sheet that's been provided by the state. And then our next court date would be pre-trial on the January 12th date, understanding that it may be later if he's incarcerated. Take that with you, and I'll come talk to you about it. Judge, this is Mr. Takia Washington before the court. There are 2 case numbers. 23 CF 699 is on Your Honor's docket. He has been served in the 23 CF 1691, but I believe it still needs to be opened within the clerk's side. Is that correct?
699 is the only one on the docket. I'll double check to see if
Okay.
it's been served on the other one.
He has been served in the 23 CF 1691. And Judge, in both of those case numbers, what I'd like to do is bring this back next week for a change of plea next Thursday. I was provided a score sheet this morning that I need to review with Mr. Washington. I discussed it with him in the attorney-client room. He had additional questions for me related to the score sheet. So I believe that would be best served by coming back next week.
And you think with that you'll be able to have a disposition, you think?
Yes, Your Honor. I know Mr. Washington wishes to move forward with the plea, but he did have additional questions related to the
You've got
score
to
sheet.
get those answered so it can be a free and voluntary plea. So we'll reset it on the 18th at 9.
I'll come see you Monday or Tuesday next week.
Next will be Mason Weston.
And next, we'll pop over to, after we're finished this, we're going to take Caden Stewart, who's now on remotely, after we dispose of this. And that's a motion to withdraw the capias.
A plea agreement that is a plea to the bench. I'd like him to read this fully through and then come back, if the court will allow.
All right? Yes, sir.
If we could just hold him and bring him back.
All right. Caden Stewart, excuse me, Caden Stewart. All right, you able to hear us? We cannot hear you. No, sir.
Thank you.
No, sir, we can't hear you.
Now, Judge?
Yes.
Perfect, thank you.
All right, this, I believe, was the defendant's self-represented motion to withdraw the capias, as the state had the benefit of the motion.
Yes, sir.
What's the state's position?
The state's position is that we would agree to withdraw. We paid the $2,007.46 to Buddy's Home Furnishings, and the state will drop the case upon the restitution.
Did you hear that?
Yes, sir.
Are you able to take care of that business?
Not at this moment, but Buddies would be willing to arrange some sort of payment plan or anything of that nature. I would be very adept to that.
Well, I can't get involved in those things. I can give you a reasonable period of time to get that squared away and get the payment made, but I can't require Buddies to enter a payment plan or anything like that. The only way that could happen is if you entered a plea and made the payments under the terms of probation. Now, I could give you a reasonable period of time and reset the case out for you to get that taken care of. But I can't, it wouldn't be years. You can't do that.
That's understandable, sir.
All right, so
What does a reasonable time look like for the court?
Mr. Snell, how much time would you give the defendant to take care of doing this as a PAD?
Could he do it in 60 days?
Think you can get it done in 60 days?
60, can I get 90, Judge?
Mr. Snell.
I'd be okay with that.
All right, Madam Clerk, give us a miscellaneous date 90 days out.
And one more time, Your Honor, what is the amount that I owe Buddy's Furniture?
$2,007.46.
Yes, sir.
Do you have a pen?
Yeah, yes, sir.
Okay, so the address where the payment would go, I can give you their address and I'll give you their business phone number, okay?
Thank you, sir.
It's 99 Eglin Parkway, Northeast, 6A. So I guess it's the unit is 6A. That's
Yes, sir.
each. It's 32548. Eight five zero 275-0111.
Yes, sir. And do I need to send a receipt to the court after I make my payment with Buddy's Furniture?
Yes, and if I could give him, I'd like him to send it to me, and I could
Yeah,
take that.
that would be the best if you send it to
Yeah.
the state attorney's office. You want to give him your address?
I can. You have the ability to, for email?
Yes, sir.
DSNELL at OSA, the numeral 1.org. And do you have a contact number that I can reach you at?
I think.
Yes, would you like,
Wasn't that on your communication?
Yes, sir. The motion I filed has both my email address as well as my mailing address and phone
I'll
number.
reach out to you.
All right.
Thank you, Mr. Snow.
And so we'll reset this for 3:12, get that taken care of, and send the information to Mr. Snell, and we'll see you on 3:12. Then remote.
Thank you, Judge Stone.
Remote appearance is permitted.
Thank you so much, Judge Stone.
Thank you now, good day.
You have a good day.
The capias is withdrawn.
Perfect. Am I good to go?
Yes, sir, you're good. Thank you now.
All right. Happy holidays. Bye.
Should have made a condition also that he gets a better microphone. We were all inside the trash can.
All right, good morning. You're here today without an attorney. Do you want an attorney to represent you?
I'll have one by, next court date.
All right, so you've already talked to somebody?
Yes, sir.
All right, who have you talked to?
Mr. Madden.
All right. When can you make those arrangements?
You said when?
Yeah, because I just want you to know when I need to reset this, that's all.
I made it about a week ago.
So if I set it for next Thursday, is that gonna be too quick?
That should be good, yes.
All right, set for 12/18 at 9 o'clock.
Okay.
All right, thank you.
Thank you.
Casey Nelson, Mr. Carter.
Yes, Your Honor, we have Mr. Casey Nelson. I would ask that we set this for the next court date. I've just been appointed, and I haven't even had a chance to talk to the state or look at the case.
All right, continue to
The next DOP date, Your Honor.
the 18th, next week, is that too soon?
Yes, Your Honor, that'll give me time to speak to him and talk to the
Okay.
state.
12/18 at 9 o'clock.
Thank you, Your Honor.
Thank you.
Thank you now.
Your Honor, may I have that case number?
That's 2020 CF 1180.
I was wondering too, I was trying to figure out where this is at.
I'm ready for Steve Martin whenever. Kelly Midget. Your Honor, we have Ms. Kelly Midget, 4S22 CF 2562. Your Honor, I'm going to ask to set this for January 15th, but in the meantime, the state and I have agreed to a bond of $1,000. I have a typed order here. If I may
All right,
approach.
so set for 112.
Or 115, I'm sorry, the next VOP date.
All right,
Excuse me.
115, okay.
And I have an order here.
State's agreeable to the bond conditions stated.
He showed us the type of stipulated motion.
Yes, that should.
All right. And that's cash or professional?
Yes, Your Honor.
All right. So ordered.
Thank you, Your Honor.
Yeah, you'll have an estimate of what's for that, but don't worry, we'll take care of it.
All right, good afternoon. You're here today on two separate cases, 2024 CF 2506 and 2025 CF 96. You're here today without a lawyer. Do you want a lawyer to help you?
Yes, Your Honor.
You able to afford one on your own?
No, Your Honor.
The public defender will be appointed to represent you.
Good morning.
Come on.
Judge, if I may see if you do have an offer potentially?
Adjudication of guilt, 6 months in the Okaloosa County Jail, revoked and terminated.
For both cases? One second. Judge, may I have just a brief moment to speak with
Yes.
Ms. Parsons? Judge, at this time, we'll be entering a denial. If I can get the next court date without subpoenas, so I can get squared away on this case.
My animals are gonna die, please.
I have court dates. I can always advance you on court dates, but
They're gonna die. I can't do this, please. I just started Bridgeway Detox. And oh my God, please. I've been doing all the courses on Adobo. I've been trying to do everything right.
All right, so
can I get the January date without subpoenas, Judge, and I can always, one second. My judge, this court, we have court next week, I can always advance it, but we need to talk privately.
Okay, so we'll set it without subpoenas on the 15th.
Of January.
And then if you've got a resolution, you know I'm here next Thursday, and I'm here the following Wednesday as well. So if you've got a resolution, you can advance it to either one of those dates.
Yes, Judge.
My animals are gonna die. I don't have anybody to get them. Please, please. I'll put an ankle monitor on, anything, anything. Jesus,
Judge,
please.
if you,
Sorry.
Steve Martin.
This is the agreement we discussed, you'll admit, adjudicate.
There's two other cases.
I think we already are. Term and revoke 38.55 months with credit for time.
Here we have Mr. Steve Martin, case number 24 CF 2474. Your Honor, today my client is going to enter a plea. We will admit the violation, adjudicate, if not already adjudicated, term and revoke. It'll be 38 and a half months, Department of Correction, with credit for time served, cost of prosecution, cost of defense. If I may approach, I have the signed plea form in the score sheet.
Granted. Raise your right hand, Mr. Martin. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir, Your Honor.
All right, and you put your hand down. You heard Mr. Cochran said you signed the written plea form.
Yes, sir, Your Honor.
All right, you understand by this plea arrangement you're admitting the violation.
Yes, sir, Your Honor.
That tells me, yep, I violated just the way that affidavit report says I did.
Yes, sir, Your Honor.
And you understand by making this plea, you're waiving your right to a hearing where the state would have to prove your violation.
Yes, Your Honor.
All right? In this case, you've already been adjudicated. You will your probation will be revoked and terminated. Sentenced to 38.55 months, Department of Corrections credit for all time served. You'll have $100 cost of prosecution, $150 state-provided legal assistance, and any other outstanding costs, I'll provide you 24 months to pay those after your release. Okay?
Yes, sir, Your Honor.
Mr. Cochran answered all your questions about the plea and how it affects you.
Yes, sir, Your Honor.
Satisfied with what he's done for you?
Yes, sir, Your Honor.
I'll find the plea to be freely and voluntarily entered into and accept the plea. Thank you.
Thank you.
Thank you, Your Honor.
And Merry Christmas, Happy New Year, everybody.
Richard Rao. Well, that's our pretrial detention, right?
Judge, I don't think any of the pretrial detentions are going to be actual hearings.
Okay. All right.
I spoke with her, Scott's for the peer version, if not, I can go in and system. So I'm ready.
Good afternoon, Your Honor.
Good afternoon, sir.
Michael Weinstock on behalf of Richard Rao. This is case number 25 CF 2329. We're here on the state's motion for pretrial detention. Mr. Snell just tells me he's willing to stipulate to a bond. The question, of course, is how much. I'd like to point out to the court, if I may, that
So the state does not intend to proceed with the pretrial detention motion?
No, sir.
So we just need to set a bond.
That's correct. The state is going to request the court to set the bond at $50,000 cash or professional with no contact with the alleged victim, weekly reporting with pretrial services.
So standard conditions.
Yes, sir.
I would like to make a few comments.
Well, I hadn't accepted that yet. I just wanted to hear what they said, and then I'll listen to what you have to say.
I've watched the video of the incident, and it's egregious. And so that's the basis for the $50,000 request, Your Honor.
And we were here last week, and you hadn't had the opportunity to speak to the victims. You've now had the opportunity to speak with them and discharge your constitutional obligation.
That's correct. Yes, sir.
Okay. Okay. Go ahead, Mr. Weinstock. What would you like me to
Your Honor,
consider?
I'll point out, if I can, that Mr. Rao is a 7-year resident of Valparaiso, and prior to that, he was a 30-year firefighter out in Broward County. I believe his criminal history, the last criminal history he had was over 40 years ago for possession of marijuana, and that was it. The pretrial release risk assessment and the documentation is 0, right there. This is an accident. It's a one-off it's a one-off accident. And we're requesting that the court, if the court is inclined to give a monetary value of the bail, since he is a retired gentleman right now, he's 71 years old, I request that the court give a bail of no more than $5,000.
All right, so let me put your client under oath, and let's hear the factors under 903-046 so that I can make the findings necessary. Raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
All right.
I'm sorry.
I need to hear the testimony of the factors under 903-046 with residents, contact with the community, so on and so forth.
How long, where do you currently live?
287 South Bay Shore Drive in Valparaiso, Florida, 32580.
How many years have you lived there?
I've lived there 7 years, and I've got about all my life savings and everything, retirement and everything invested in that house.
All right. Prior to retiring, what kind of work did you do?
Prior to retiring, I was a firefighter, driver engineer. I drove many fire trucks and extricated a lot of people out of cars, and that's why I wanted to say something to those young people. I thought they're in the car that they
No,
almost...
no, sir, don't talk about the facts of the case.
What was the
Anything
next
you say
question?
here will be used against you. The state's ready to make, we're making a recording. Don't talk about the facts of the
Okay,
case.
So how many years were you a firefighter?
I was a firefighter for 30 years.
On your previous criminal history, have you ever been arrested?
No.
Don't you have a marijuana charge?
It's like 40 years ago,
Okay. on there.
50 years ago. It's 50 years ago. It's 20-something.
Okay. All right, and according to what the prosecution said, that he reviewed the videos and it was egregious. Did you intend to hit this woman with your car side view mirror?
Well, hold on now. I don't want to get in the facts of the case, Mr. Weinstein.
All right.
I'm talking about the 903-046 factors, which are the factors the court's supposed to consider in determining the appropriateness of the bond.
All right. Well, that's all, Your Honor, except I'll point out one more time that pretrial release risk assessment is 0.
All right.
I had no bad intent.
Do you wish to inquire regarding those factors, Mr. Snell?
No, sir.
What's your girlfriend's name?
All right.
636-399-6209. You gotta tell her
Yeah.
where your people
All right. It'll be a $5,000 cash for professional bond, standard conditions, pretrial service, weekly reporting, no contact with the victims or any witnesses, and otherwise comply with pretrial services conditions.
All right, thank you, Judge.
Thank you, Your Honor.
And I'll expect a written order from you, Mr. Weinstock, that details those conditions. He'll have to meet with pretrial services before he's released. That order will have to be completed before they release him to the jail.
Okay, pretrial services, no contact with the alleged victim, and what other issues?
It's 5,000 cash or professional, standard pretrial services conditions, no contact with the victim or any witnesses, and weekly reporting with pretrial services.
All right, thank you, Your Honor.
And the only reason I'm being fastidious about these written orders is because we're experiencing some issues with the progress docket being completely accurate and and being consistent with, congruent with what the jail has. We've experienced several different problems. That's the reason I'm requiring written orders on all of these cases now.
All right, I'll prepare the order when I get back to the office. Can I send it directly to Franny?
Yes, sir, and she'll inform me and I'll sign it straight away.
All right, thank you.
All right.
Next, we have Tiffany Scarborough.
Scarborough, please.
Judge, this is 25 CF 1453. If I may have a brief moment, Your Honor.
You may, sir.
Judge, it's my understanding Mr. Snell is not going to move forward with the pretrial detention this afternoon. Mr. Snell is going to ask for $50,000 cash or professional for the burglary of the unoccupied dwelling, and then $5,000 cash professional for the grand theft, Your Honor. Defense has no objection to setting that bond. And I just want to make the court aware my client has an additional case in this courtroom. That's the 25 CF 1453 case, and that's currently no bond, Your Honor.
All right. And the state agrees to that?
Yes, sir.
All right. And you'll produce a separate order with that for me, please?
Absolutely.
All right, very good.
Yep.
Good afternoon, Mr. Kleins.
Hey, Your Honor, how are you?
Good, welcome back.
Thank you.
And you're here for Dwayne Cobb, right?
That's correct, Your Honor. So just to, I know this is ultimately going to go to Judge Clark. We actually finished taking all of the testimony in the detention hearing last Thursday. And right before we started making our arguments, Judge Oberleisen informed us of a potential matter that would require or could lead to a recusal, which is why this is in front of Your Honor today. But I talked with Ms. Jaquith earlier. I have been informed that the co-defendant's case has been assigned to Division 1. I'm assuming Mr. Cobb will go to Division 1. I was just about to walk out the door and Ms. Jaquith called me and said that the detention hearing is not going forward today. So that's why I'm on Zoom.
All right, so we'll reset this at 12:30, 12:18 at 12:30 in front of Judge Clark?
Yes, Your Honor.
That's fine, Your Honor. Yes, that was.
Let's have the defendant so they can hear. Yes.
Sure. And Your Honor, I don't know if you want me to explain this to Mr. Cobb or if you wanted to do that, but
All right, good afternoon, Mr. Cobb. Mr. Kleins is here from Ms. Jaquit's office, and what's happening is I believe you had a hearing last week, and at the end of that hearing, Judge Oberleisen recused, and it came here. However, your co-defendant is in Judge Clark's division, so therefore, your case is going to be moved to Judge Clark's division. And so this matter will be continued in front of Judge Clark on 12/18 so that she can dispose of all the cases together.
Yes, sir.
Okay?
Yes, sir.
All right, thank you very much. Good day.
All right.
Thank you, Mr. Kleins.
I appreciate it, Your Honor. Everybody have a good Christmas.
You too, Mr. Kleins. Good day.
Bye-bye.
All right, Chase Payne. All right, you're here today without an attorney, and we're here for a pretrial detention. Where are we going, State?
We are going to be filing a motion here either this afternoon or tomorrow morning. I reached out, there's 2 victims that are listed. My office has spoken with one of them. I was hoping she was gonna be here today. She said she was going to try to be. I need to speak with them. Our intent is to move forward with the pretrial detention hearing at this time. I will get that motion filed either this afternoon or tomorrow morning, and then proceed forward. But my thought was, given that I don't believe Mr. Payne has an attorney, it might be in his best interest to appoint him an attorney. I can get the discovery that we do have over to that attorney so that they can be prepared for the hearing next Thursday.
Yes, sir. Based upon the nature of the charge against you, this has been set for a pretrial detention motion under the statute. The state's indicated they will file a pretrial detention motion. You're not presently represented by an attorney. A pretrial detention hearing is a formal evidentiary hearing where the state is entitled to present evidence to persuade the court that you should be held without bond under the statute, which is statute 907-041. Are you able to afford an attorney on your own?
No, sir, and I'm on probation. So that's what I was trying to say the last time. But I'm on probation, but the thing is like, I got the proof on my phone. It wasn't a...
Well, don't talk about the facts of the case,
Right.
because if you talk about the facts of the case, we're making a recording, they're going to take notes, anything you say can be used against you. Do you know what your probation case number is?
No.
I was looking up, I only looked up through CCIS. I didn't see any. Is it in Okaloosa County that you're on probation?
Yeah.
It's not an Okaloosa County case. He was transferred here.
Okay, well, that explains that. All right, I'll appoint the public defender to represent you in this case. You can chat about the evidence on your phone and all the other stuff that you have. That way, they can help you present that evidence at the pretrial detention hearing, okay? Or they can talk to the state and explain what's going on and maybe convince the state that it's not proper for a pretrial detention. That way, your lawyer can convey that information and you won't violate your right to remain silent. Does that make sense?
Yes, sir.
Okay.
Is
So
there-
I'll appoint the PD to represent you in this case. And you want just a second, Mr. Koch, to talk to your
Yes,
client?
thank you. still let me represent you? Okay. Judge, thank you for that additional time. I'm gonna get this case file open and be prepared for next week.
All right. And you share your evidence with your lawyer, and maybe he can convince the state to do something other than what they plan on doing at this time. But that way it preserves your right to remain silent and protects you against incriminating yourself, okay? All right? So we'll set this for 12/18, and if something else is done sooner, just let me know, and I'll make myself available.
Thanks, Judge.
All right, thank you. All right, then, yeah, I'll counsel if you approach real quick. All right, so for whatever reason, I had Shaquem Hall on for this afternoon, but I also show that that was pled on 10/16.
Yes, sir, and that's with Mr. Gomez. May I approach?
Granted. All right, then I also show, I'm not sure why, William Martinez Gonzalez on the docket today, but I also show that was pled on 6/12.
Yes, Your Honor. He was in mental health court as And he was just released from the 90-day program, and apparently he did not check in as he was supposed to afterwards. Per the affidavit, I have not had contact with him.
So there's a OTTIC? Is that what we have?
Oh, what, Your Honor?
Oh, order taking into custody?
I believe there should be
I believe
one.
there was one of them.
So how did we end up on a docket?
When he was released from the 90-day
Oh, he
program,
automatically came over here?
they automatically set it here.
Do you see the OTTIC, Madam Clerk?
Yes, Your Honor.
Okay, just take it off the docket until it's served. Robert Eugene Mathis?
Yes, Your Honor, he refused transport today from the jail.
All right, well, what we were here for today?
It was supposed to be a plea, Your Honor. I have previously discussed a plea with him that he accepted. At the last plea date, at the last minute, he rejected it. He was supposed to come back today, because at the end of, after he rejected it and they put him on the bus, he stated he wanted the plea, and so we reset him, and he refused to come today.
All right, so what, should we just set it for trial?
Evidentiary hearing?
I mean, yeah, an evidentiary hearing?
Yes, Your Honor. I'd ask to
Okay,
set it-
so we'll do 115 with subs. Okay?
Yes, sir.
Nothing like a trial to get a case resolved one way or the other.
That's right.
All right, then I show Travis McLemore,
Yes, Your Honor, he is in federal custody.
still in federal custody.
Yes, Your Honor.
So what do we
Sure.
want to do with Travis McLemore? State? Because
We generally want to wait.
this is our 1, 2, 3, 4, 5th docket where we're just reporting he's in federal custody.
Your Honor, I would ask if we could kick it out an extended time, to see what happens with the federal case.
I don't want to necessarily dispose of this case until we have at least something that
All right, so what, 3 cycles?
I'm okay with.
Yes, Your Honor.
Madam Clerk, that would be May 11,
Yes, Your Honor.
and we're calling that status, right?
Yes, Your Honor.
Okay. Next, I show Dana Melson.
Yes, Your Honor, that's Mr. Knope's case. We set that on for a competency status. There was a competency evaluation filed by the Florida State Hospital, I believe, about a month ago, or slightly less. She is still incompetent to proceed, so I think we just need to set it on another status date.
So 6 months out,
Yes, Your Honor.
Madam Clerk?
June 11th?
And just to refresh, when I first rotated back, I was not doing this, but now that we see that we're still having issues with these getting set regularly, I'm going to start, I want your help to be sure that we put these folks on regularly every 6 months. That way, it'll tickle us to be sure that we check in and we don't end up with any petitions, right? Which we don't need.
Yes, Your
All
Honor.
right, so just be sure, check your files, and if we've got anybody who's in that status, let me know, and we'll set them for a status. And that'll prompt us all to be sure that we're getting what we need, okay? All right? Say again that date, Madam Clerk.
June 11th at 9.
6/11. All right, Johanna Miller.
She pled out, Your Honor.
Yeah, 7/21, so how do we?
No, she pled out today.
Oh, she pled.
She had a VOP, yes.
Yeah, it was a
That's
VOP.
right,
She
the
pled out
VOP,
this morning.
that's right.
That was modify and add 48 hours.
That's right. Mullenhour.
That was I filed a no cost, Your Honor. They provided receipt of full payment of all of the costs and restitution.
You got that, Madam Clerk?
already paid and you're announcing a no cross.
That's correct.
All right, Nano.
Yes, Your Honor, this is good, this was, we filed a motion to withdraw, we had a notice from the clerk that he wasn't indigent. My office had not had contact with him yet. I'd asked to leave this set for the January 12th, because I don't believe he was given notice of this hearing.
Yeah, so he would have the ability to come in and challenge the finding.
Yes, Your Honor, and
Okay.
he was previously scheduled for January 12th, so he knows about that court date.
Okay, so we'll just leave it set for January 12th.
Thank you, Your Honor.
And then, did we take care of Mason Weston?
We have not, Judge. I asked for him to come back,
Okay, and Rico Williams.
and I need to speak with the state before we bring Mr. Williams out.
Okay. We got anybody, well, we're getting close to our time. So let's take care of those two and then we'll do our recess.
Those two. I still need time to speak with the state on Mr. Williams. Mr. Weston may be a little bit more time if we go to a pleaded bench.
Okay. Let's do the 130s then, as many we can, and then before our recess. Let me know when you're ready.
Yes, Your Honor, we have Mr. Orville Madden, case number 25 CF 2030. We'd enter a plea of not guilty, waive formal reading, and ask for the next court date.
Madam Clerk?
January 12th.
All right, set for 112. Thank you now.
Copy of this information.
I'll get Discovery together and come see it.
All right.
You can give it 10.
Next we have Ernest Merritt.
And state, sound off with your offers as they come out, please.
That was 100, that was, yeah, he made it.
Yeah, that was a 7-year min-man offer.
Okay.
Your Honor, I have Mr. Donald McLean, 25 CF 2033.
No.
I'm sorry, I have
Ernest
Mr.
Merritt.
Merritt. Wrong page. I have Mr. Merritt, 25 CF 2267 and 25 CF 2268. At this time, Your Honor, I do have a plea offer from the state, which would be an adjudication of guilt, 3 years probation, restitution in the amount of $3,973.40 to Mr. Wilson, no contact, and no trespass at storage. You'll take that? Okay, Your Honor, we'll bring him back this afternoon. I'll type up the plea.
All right.
I will get you back in probably after too, because the judge has to. All right? All right, Your Honor, next we have Mr. Scott Orange, 25 CF 2197. Your Honor, we're gonna enter a plea of not guilty, waive formal reading, and ask to be set the next court date.
Madam Clerk?
January 12th.
112.
Was this information?
Is he power of attorney to make decisions for
No, just
Tell him to
for
call the
the
office.
record, the offer, and that was a 25-year PhD offer with a 25-year minimum.
And I did just relay that to my client. That 25-year.
Reese.
Judge, this is Mr. Reese, 25 CF 2142. Yes, Your Honor. We're going to enter a not guilty on all counts, waive formal reading. Request this be kept on that pretrial docket. Your Honor, count 1, and this is still allegations, we haven't received FDLE, is trafficking in fentanyl, the min-man of 7 years.
Okay. Madam Clerk, next court date?
January 12th.
112.
Thank you, Judge.
Thank you.
Next we have Virginia Indiana.
That's 25 CF 2150 for Mr. Robinson, Your Honor. Yes. 112. Yep. I believe all these are going to be there. Yes, Your Honor. This is Mr. Robinson. We'll acknowledge count 1, enter not guilty, waive formal reading. Judge, the current offer is 36 months DOC. So requesting this be kept on the next pretrial. I believe that is the 112 January docket.
All right, 112.
Copy of information.
Yes.
He needs a copy of the information.
Thank you.
Who's next?
See, it's time, get your ties. So this is Mr. Timothy Francis Ties before the court in 25 CF 2232. We would acknowledge the receipt of a 5-count information, waive its formal reading, and or plea of not guilty. Ask for this to remain on the next pretrial court date.
And for the record, the defendant does score 69.750 months. State's offer would be 7 years in the Department of Corrections, followed by 10 years of probation.
Can we have
And
that?
say again, so 69.75 is the guideline and the offer is?
The defendant scores 69.750 months. That's about 5.8 years. State's offer would be 7 years in the Department of Corrections, followed by 10 years of sex offender probation.
Judge will maintain the not guilty plea.
All right, and 112, Madam Clerk?
Yes, Your Honor.
All right, so ordered.
This is Andrew Walters.
Judge, this is Mr. Andrew Walters before the court in 25 CF 2244. We would acknowledge the receipt. Is this a 2-count information?
And for the record, the defendant scores 34.5 months. However, due to prior criminal history, state's offer would be 8 years in the Department of Corrections, followed by 10 years of sex offender probation.
That was 8 followed by 10 years probation?
Yes, sir.
Judge, we will acknowledge the receipt of the 2-count information, waive its formal reading and or plea of not guilty, and ask for this to remain on the next available pretrial.
112, Madam Clerk?
It's currently set for 114, but would you like them to change?
112?
12. 112.
Julio Ramos Perez.
All right, good afternoon. You're here today without an attorney. Do you want an attorney to help you?
I got attorney, Mike
Gates did.
Gate.
A not guilty plea.
He did file a written plea of not guilty?
Yes, Your Honor.
Okay, and it's set for what day?
January 12th.
Okay, yes, sir. Your written plea of not guilty is set, was filed, and you're set for 112. Thank you.
Thank you.
Next is Dennis Rios Mejia.
When was that done? Did you not get it in time?
Terrell, Doris Terrell.
Done yesterday.
Okay.
Terrell.
All right, good afternoon. You're here today without an attorney. Do you want an attorney to help you?
Yes.
Are you able to afford one on your own?
No, sir.
All right, I'll appoint the public defender to represent you in this case. Have information?
Judge, we're here for arraignment. We would acknowledge the receipt of one count, information, waive its formal reading, and a plea of not guilty.
Is there an offer?
Judge, he has in other cases with Ms. Dudley as the attorney. I think they are scheduled for the next pretrial, so I'm unsure if the state would have an offer for this case separated out from the others.
All right. All right, we'll set this for 112. Thank you.
Judge, it's 5 till.
Say again?
It's 5 till.
Yes, and we're waiting for the interpreter. We'll do the last one. So let's get Dennis Rios Meja. And Madam Interpreter, you swear to interpret these proceedings truthfully, adding nothing and subtracting nothing?
I do.
Good afternoon, sir.
Buenas tardes.
You're here without a lawyer.
Está aquí usted sin un abogado.
Do you want a lawyer to help you?
¿Quiere un abogado que le asista?
Sí.
Yes.
Are you able to afford one on your own?
¿Usted puede pagar uno por su cuenta propia?
Sí.
Yes.
Have you talked to a lawyer
¿Usted
yet?
ha hablado con algún abogado?
Sí. La puerta que viene con un abogado, pero no sé qué pasó.
The first court that I appeared, I did have an attorney, but I'm not sure what happened.
They announced at the time that they were limited representation just for the pretrial detention
Para
hearing.
la audiencia nada más de detención preventiva.
Who was that? Do you recall?
He had dual counsel. He had Thomas LaPella, Krista Divini.
Y la señora Crista
Divini. I botched that, sorry. And we were before Judge Clark on that day.
Right, and I see that that was a limited notice of appearance. It is my understanding that those lawyers will not be representing you anymore. Do you wish still to try to seek private counsel?
Yes.
All right, so I'll reset this for 12/18. Is there our next arraignment? When's our next arraignment? 12/18. You need to reach out to the lawyers and see if you can make arrangements to represent you. Okay? All right, thank you. All right, we'll see you after a while.
Just